All right, then. Good afternoon, everyone, and thank you for joining us. I'm Robert Baylor, Director of Communications at NUCA. Welcome to NUCA's Summer 2025 Washington Update. First, before we begin, some webinar housekeeping for attendees. Today's webinar will be recorded. It will be available on NUCA's YouTube channel, both which can be accessed via NUCA.com. All participants are muted upon entry. Phone participants can use *6 to mute and unmute themselves. Questions will be asked at the end of the presentation. To ask a question, you can submit a written question at any time using the chat feature, and I'll read them at the conclusion of our discussion. Now let's get started. 6 months ago, the Trump administration returned to office for their second term. It's been a whirlwind of activity, from imposing new tariffs to the months-long battle to sign into law the One Big Beautiful Bill Act on July 4th. Our industry has been affected by these activities, some of them delivering concern and others awarding NUCA with well-earned victories, especially with the workforce development legislation advocated by our members at May's Washington Summit. And this year is not over. Last year and in 2023, NUCA was able to prevent nearly $2 billion in cuts from our industry's two state revolving fund programs. Unfortunately, as of this week, proposed SRF cuts are back in play in the House. A top legislative goal this year is now to remove these cuts from the pending fiscal year 2026 Interior EPA appropriations bill. Today's summer 2025 briefing will be presented by Zack Perconti, NUCA's talented Vice President of Government Affairs. Thank you for joining us today for this member-only NUCA briefing. Zack, I turn the webinar over to you.
Thanks, Bob. There is a lot to get through for today. I apologize in advance, folks. This is going to be a rather text-heavy webinar, but I'm going to do my best to cover everything that's been going on in Washington. I'm going to spotlight a couple of particular issues of importance, and then at the end, we'll go ahead and do some Q&A, as well as just some brief discussion of the many other things that are happening in DC that we just do not have enough time to cover in this next hour. But the first thing I want to do is really cover what set the stage for much of what we're going to discuss today, and that is the May 2025 Washington Summit. Now, thank you right up at front to those of you who were able to attend and join us. I think it was a tremendously successful event this year. We had some great speakers. We had some great meetings. We did, I think, a pretty good job of conveying what was important to our industry, to lawmakers on Capitol Hill, at a critical time in this year's, this 119th Congress's legislative session. When we were in Washington, Congress was in the middle of really getting the One Big Beautiful Bill discussions off the ground. We saw the final result of those negotiations, which was passage on July 4th, as the president had stated was his deadline. While we as an organization did not take a particular stance on the overall bill, there were a number of things that we talked about at the Washington Summit that were directly reflected in the final legislation. And I'll get to that in just a moment. As you can see, and have no doubt have heard, this was one of our larger summits. We had 106 attendees with 120 meetings across Capitol Hill. I think that's great. Well, we're hoping to grow it even bigger next year, of course. But from the attendees we had, we were able to cover a lot of ground, meet with a lot of key offices, and keep that momentum going into the celebration of construction on the National Mall that immediately followed our summit. So again, this year, we partnered with a number of our associate manufacturer members, some of our allied trade associations, and the associated equipment manufacturers to take over a few blocks of the National Mall, bring in a bunch of real cool pieces of construction equipment, set up some booths, and really just educate both the general public, local media, and lawmakers and policymakers about the importance of our industry. And I think that event, from what NUCA put into it and what our members put into it, was a tremendous success as well. We had great attendance. We had a lot of folks stop by the NUCA booth. We also had a lot of lawmakers and policymakers visit us on both official and unofficial tours of the event. And many thanks to those of you who helped coordinate those. Some very high-profile folks stopped by, including one of the FCC commissioners, the U.S. Environmental Protection Agency's Office of Water. We had a quick interaction with the U.S. Secretary of Transportation, and we even had a one-on-one meeting with the Small Business Administrator. Many thanks to our DC chapter and past DC chapter president, Gabe Santos, for having a one-on-one conversation with her as a part of her tour of the event. So it's been just an absolutely great event that we were happy to be a part of. And we're really looking forward to participating in that again. But it was particularly timely this year because of where it fit into the overall legislative agenda. By presenting real pieces of equipment, real conversations, real contractors to these lawmakers, both on the mall and at the summit, we were able to directly shape some of the conversations around the One Big Beautiful Bill and really directly impact what made it in and what did not make it in. And that has paid off in a big way because we have quite the long list of legislative accomplishments since May of this year. We had 3 included within the One Big Beautiful Bill, or OBBB, as I'll refer to it from now on. And most notably, a multi-year effort to create a pathway to use federal financial aid for the trades finally paid off with the creation of the Workforce Pell Grant program. If you were at our Washington Summit, you'll recall we've talked about the Bipartisan Workforce Pell Grant Act in previous years. This year, we also talked about the Jobs Act. Language very similar to those bills was included in the legislation. And that now opens up tremendous opportunities and new pathways for folks to go into the trades and go into our industry. So I really can't stress enough how big of a win that is for us. It's not often that you work on something for a couple of years and you get such a big win in our industry. And I'm really excited to work with all of you on actually implementing those programs moving forward. We also had a number of pretty significant tax changes that we'd advocated for the last couple of years. Those were mostly included in the legislation, which is a pretty big positive for us. And continuing our ongoing work towards permit reform, there were a couple of small tweaks to permitting for big projects that were included in the bill. And we'll talk about those a little more in detail as well. We've also got a win that's currently in progress. You may have seen a note in one of our recent newsletters, a package of Clean Water Act permitting reforms, which conveniently has been dubbed the Permit Act, recently advanced out of the House Transportation Committee. We're hearing that it's likely going to move to the floor, probably some point next week. You may see more from us ahead of that bill, moving for a full vote, asking for your support. This is not the end of this fight. Of course, it still has to go through the Senate, but we remain pretty encouraged by the willingness of not only the majority, but also folks to consider bipartisan solutions to streamline the permit process and help us build this country's underground infrastructure. The other good thing about the Permit Act that we're hearing is it's quite possible that the next thing that the Transportation Committee turns its eye to is the state revolving fund reauthorization. So that work does remain on track. Now, I am not a tax policy professional. I am not a tax expert. So I am going to cover this at a pretty high level and not really dive into a lot of the specifics on these issues. But the good news for our industry and for business owners, by and large, most of the tax changes that we've advocated for the last couple of years were included in this bill. And this kind of goes back to 2017 in many respects. The signature accomplishment, legislative speaking, of the first Trump administration was probably the Tax Cuts and Jobs Act, which was also a big reconciliation package. And that was the initial source of many of the provisions that ended up in OBBB. The challenge was that many of those provisions were set to expire either at the end of this year, the end of the next fiscal year, or in some cases had already expired. And so many business owners were, and many companies were set to see a pretty significant tax increase in the very near future. For the most part, we've been able to avoid that. And we were able to have many of the critical provisions that we've supported and advocated for pretty strongly over the last couple of years included, expanded in some cases, or restored in others in this legislation. So the good news there, 100% bonus depreciation is once again back on the table. So, if you're looking to buy new or used equipment, you can fully deduct that the year that you buy it. Likewise, for especially our associate members and manufacturers, 100% R&D expensing has been made permanent. For our pass-through members and small businesses, the good news for you is that the 2017 individual tax rates have been made permanent. The 199A qualified business income deduction has been made permanent. The estate tax exemption has been made permanent, increased, and indexed to inflation. And that'll provide a lot of relief for those members in particular. For others, the corporate tax rate remains 21%. They decided against increasing that rate, which I think is pretty good news for many of our businesses. Now, there are a whole host of other provisions in there, which in the interest of time, I'm going to breeze through. But the other one that I really do want to spotlight for everyone is when there were conversations around how they were going to pay for this reconciliation package. For a time, eliminating the tax exemption on municipal bonds was very, very seriously proposed. That would have hurt construction pretty severely. A lot of communities would not have been able to finance projects, which meant work would fall off, particularly in communities which really lean heavily on municipal bonds to finance that construction, as many do. That exemption was preserved. So that is very important. I don't think it's necessarily the end of this fight. It may come back up. We'll talk a little later about some of the other possible action that Congress may take around that and other tax issues. But in the short term, at the very least, there's good news there. And for many of your employees, they'll be pleased to hear that there was at least a limited overtime, no tax on overtime deduction included. So I'm going to switch gears here and talk about the federal water infrastructure reauthorization and appropriations process, because this is really the most mixed bag out of anything we're going to cover today. So everyone here is probably at this point at least somewhat familiar with the president's budget request. You've probably heard me scream about it at least once. It's very frustrating. Unfortunately, the president's EPA and the EPA Office of Water, they've said a lot of great things about the state revolving fund programs. They know how important they are. But when the president released his budget request, it kind of was a bit of a shock to a lot of folks because it didn't seem like that was what the mentality was within EPA leadership, including EPA Administrator Zeldin. You can see the excerpt directly from the EPA budget request linked here. We, to put it bluntly, do not agree with the recommended reduction or the rationale for said recommended reduction. Proposal to cut funding down to nearly 89%. And we also disagree with the stated rationale that this would be a phase out of federal funding altogether. The implication here being that the president recommends a funding level of $305 million for fiscal 26 across both programs and a complete elimination of that funding moving forward. We've talked many, many times about the percentage of funding that comes from the federal government versus the states. The states provide far more funding to the SRFs right now than the federal government does at this point in time. And they can't afford to lose that small amount of federal funding. Not only will it, eliminate the opportunity for countless projects around the country, but it would also just create a situation in which the programs didn't even have the funds to be administered properly. Now, the only thing in there that we do agree with is the rationale around earmarks, but I'll get to that in a moment. The good news here is that Congress has largely signaled their intent to completely disregard this budget request, at least when it comes to this program. In many other programs, they've actually moved to codify what the president recommended. So that in and of itself is a little bit of a win for us. The worst case scenario has likely been avoided. However, that does not mean that we are in a good position right now, because once again, we are looking at a House appropriations bill that proposes pretty significant cuts to the clean water and drinking water state revolving funds. They are not at the level that some feared. There was some rumors that if they weren't going to go for an 89% cut, perhaps they'd try to cut by 50% or 40%. Instead, the cuts are coming in at about 26% for clean water and 20% for drinking water. Reduction of about 660 billion million across both programs. However, unfortunately, they are continuing the pattern of drawing community project funding or earmarks out of the assistance grants for the clean water and drinking water state revolving funds. And specifically, they're looking at taking about half of the money they have set aside for the clean water and drinking water state revolving funds for fiscal 26 and putting those as grants to specific projects in the form of earmarks. That is an issue for many reasons. We've talked about this before, but just to summarize, what that does is two things. Number one, it creates winners and losers across the country. Some states will be receiving more than they otherwise would have in terms of water infrastructure funding, and others will be receiving less than they would have gotten under the normal formula funding allocations. But the bigger issue is we're taking that money out of the revolving loan pool. And so that $660 million that are being pulled out of that revolving loan pool, that's funding that's lost to us in perpetuity. We are never going to see the long-term returns to grow the available pool of funding that we would have if those were treated as the normal low-interest revolving loans. And so it directly undermines the long-term health of the program. NUCA here, part of the reason that we try to speak up about this at the federal level is in the short term, this doesn't really harm us necessarily, at least some of us, because we're building these projects either way for the most part. But in the long term, this is undermining the health of the federal programs that deliver so much water funding nationwide and the state programs that rely on those federal dollars to continue to operate and make available revolving loan funds to communities. So in the long run, this will reduce the amount of available work. It will reduce the dollars that go into federal water infrastructure programs. It'll reduce the amount of dollars that go into water infrastructure projects all across the country. It's just not a good example of policymaking. Prior to the return of earmarks a few years ago, Congress would not take water earmarks out of the direct allocations for the clean water and drinking water state revolving funds. They would provide a pool of funding for earmarks for water projects on top of the allocations for the SRF programs. And so our ask to Congress does continue to be just go back to the way things used to be and restore the process of providing earmarks from that second pool. Many of these projects are important, but we can't afford to fund them this way. Now, these numbers are pending a full House Appropriations Committee vote. It is possible, but unlikely, that these could change by the time this goes to the full committee. What is more likely is, as has been the case in the last few years, the Senate will provide a significantly higher set of numbers, and those will be the numbers that we're supporting throughout the process. We've also heard that the Senate is more skeptical about earmarks right now. One thing that we've heard from a couple of offices, they have had communities approach them with a request for an earmark for a water infrastructure project, and the offices have essentially set a policy of you need to go through your state revolving fund first, and if for some reason that's really not an option for you, then we can discuss it. But there are a number of offices that have at least expressed to us that their current thinking was they were not interested in funding new large-scale water infrastructure projects out of the SRF appropriation. This may be one of those issues that we just make baby steps on year over year. The fate of this for fiscal 27 will largely determine on the SRF reauthorization process and if we get another set of supplemental appropriations to go with that reauthorization, the way we did in the Infrastructure Investment and Jobs Act, IIJA. As I alluded to on the last slide, the appropriators' rationale has been the SRFs have all of this money from IIJA, and so we can afford to take additional funding from their annual appropriations to use that for these projects. If you go talk to the SRFs in your states, they'll almost all tell you that they have to turn communities away anyway because they don't have the money right now. So it doesn't really make things better. It's not like we have more dollars than we know what to do with. And as always, the fight really does continue to be just getting every dollar we can for water infrastructure work. And the one bit of good news is that the Water Infrastructure Finance and Innovation Act does remain flat. They are not cutting the funding there. So really, our work continues to support the future of America's water infrastructure and, by extension, utility contractors working on those projects. We're continuing to work to fully fund water infrastructure programs. Our ask continues to be to fund these at the authorized level of $3.25 billion annually. In this environment, that's going to be very, very tough. We may once again just be settling for not funding cut, but we'll continue to work hard to pressure the Senate to provide a better set of numbers, and we'll also keep pushing the House away from these cuts that they've proposed for the third year running. We've covered the thought process on the earmarks. Again, our members are building these projects. We think every single one of these projects are important by and large. We do not think that this is the appropriate way to fund them. Those dollars need to be coming on top. It's not like we have any shortage of water infrastructure needs. And really the significant goal, the prize in many respects of this Congress, is getting a reauthorization of water infrastructure programs at or above IIJA levels from fiscal 27 through fiscal 2031. So for another 5 years. The last year of funding for those IIJA water infrastructure programs is fiscal 26. The nightmare scenario is that we don't get any sort of SRF reauthorization this Congress, and that Congress does not change the habits they've built up over the last few years around earmarks and proposed funding levels. If the House Appropriations Committee's proposal were to be next year, same numbers next year, and were to be moving forward without that supplemental IIJA money, this would be a very different webinar. I would be significantly more concerned than I am now. That's not to say that I'm not very, very concerned, but that is a nightmare apocalyptic scenario in which federal dollars for infrastructure amount to $500 million in each program that states actually have available to use as intended. That would be catastrophic for the long-term future of the SRF programs and, by extension, the long-term future of America's water infrastructure. And we need to work very, very hard to make sure that Congress doesn't fall into a pattern where the only projects that receive any federal water infrastructure dollars at all are those that they've decided to give an earmark to. Now, in terms of what's next, again, we should know relatively shortly about what the House decides to do. There is likely to be a full committee markup for those House Interior Environment numbers, likely by the end of the month. The Senate is much farther behind. I don't seriously expect movement from them until September at this point. Remember, Congress is on recess back home, back in their districts and states the entire month of August. Absolutely nothing will happen in DC that month. And the Senate will be under a pretty tight timeline to start getting stuff out by the end of September, when they either need to pass all 12 appropriations bills and get them signed by the president, or pass a continuing resolution. At this point, I think we all know it's much more likely we see a continuing resolution than Congress somehow kick into high gear and pass all 12 bills within about 6 weeks worth of time. Once they return in September, it's possible that the House Transportation Committee, will begin seriously looking at an SRF reauthorization bill, with the goal of maybe putting something on the committee's markup schedule late September, probably into October, or maybe even early November at this point. It all really depends on a couple of things. One, do they decide to work on surface transportation first, which is going to be much longer and much more complicated. 2, what does the Senate decide to do? The sense we're getting from the Senate Environment and Public Works Committee is they're likely going to do the surface transportation bill first and then move on to water. And 3, what does House Energy and Commerce do? The Senate EPW committee has both the clean water and drinking water state revolving fund programs under their jurisdiction. So that's easy. House Transportation only has the clean water SRF. House Energy and Commerce only has the drinking water SRF. To date, the Senate EPW committee and the House T&I committee have both held hearings about potentially reauthorizing the state revolving fund programs. House Energy and Commerce has not. They have been preoccupied with their very large piece of the OBBB and the reconciliation process. They also have a very large jurisdiction. It's hopeful that they'll have some sort of hearing on the Drinking Water State Revolving Fund. It's not strictly necessary that they do, but they're a little farther behind. So it's possible that this whole process may end up falling into spring 2026. But we do know they are very, very serious about it. And it's very likely that this will be one of the top items on our agenda for the next Washington summit. So I'm going to move on to surface transportation reauthorization here, because the fates of these two bills are intrinsically linked. The highway bill is in many respects a chance for IIJA 2.0. I'm sorry, I don't know why my computer is doing that. Essentially, this bill is the funding and authorization for federal surface transportation programs and spending. You'll hear it called the highway bill most commonly. This is the single largest portion of the infrastructure bill. $643 billion out of a $1.1 or so trillion price tag. And that in and of itself was a significant increase from the $305 billion FAST Act, which preceded it. Now, what happened for IJA was largely the same thing that we're envisioning happening here. Many of the other infrastructure programs essentially glommed onto the highway bill and used that to get across the finish line. This is not strictly speaking a must-pass bill for this Congress, but it may as well be in some respects. There is a strong desire from the majority in Congress to get this done and the minority in Congress to get this done. There is a strong desire from the White House to get this done. If you listen to the president and the Secretary of Transportation talk, they're all about big, beautiful roads and bridges, right? And so we're lucky in a sense that the state revolving fund reauthorization also comes at the same time that many of these programs are up for reauthorization, the end of fiscal 2026. So next September is going to be very, very significant for Congress to get all this stuff done. This is our best opportunity, not only to move SRF reauthorization, but many of our other infrastructure programs, policies, and priorities. Things like the Pipeline and Hazardous Materials Safety Administration reauthorization, which contains some damage prevention language that we've been working on for a couple of years now, may very well end up getting rolled into this package as well. Now, we have been working with many of our other industry and coalition partners on this legislation for quite some time now. There's already some draft language that's starting to circulate. This is a big, big project for the committee. It's really going to take them a lot of time to move through. But as an industry, we've already identified a number of key industry priorities. And many of these things may also apply in some way to things like the state revolving fund programs. Those priorities include full funding for essential programs, growing and stabilizing highway trust fund revenues. I know for some of our members, particularly those who are doing a lot of utility relocation work, highway trust fund dollars pay for many, many, many of the projects that make up the bulk of your company's annual revenues. So this is extremely important to us. Now, there have been many proposals on what to do there. As you may now know, Congress has not raised the gas tax in many, many years. But in some ways more striking than that, currently electric vehicle drivers do not pay into the Highway Trust Fund. Obviously, they're not using gas. Gas taxes are the primary revenues for the Highway Trust Fund. So if you're driving an EV, you are not contributing to federal dollars that pay for the roads that you're driving on. We're continuing to look for some sort of solution to the EV literal free rider problem. There was some talk of potentially including some sort of modest annual fee or other revenue generation from electric vehicles in OBBB. That was not included, but it is a priority to find some sort of agreement in the highway bill. We're also looking at some roadway construction safety, which I'll talk about on the next slide, some permit reform and regulatory process streamlining. There have been conversations around improving available financing tools like private activity bonds. Our hope is that would apply not only to road projects, but also to water infrastructure jobs. And then, just as a brief aside, we're continuing to work for clarity on Buy America requirements, potentially even asking the agencies themselves to curate a list of compliant products. That last one is very tricky because the agencies can't be seen to endorse products, to use words that they've said to me directly in some of the meetings we've had about this. But there needs to be some sort of process in place where contractors, manufacturers, distributors, municipalities are not left guessing as to whether a product is compliant or not. There needs to be a more defined process where an agency can give you firmer guidance on compliance, particularly as the strain of thought in Washington continues to be tightening what is and what is not considered compliant. And there needs to be a process in place where, again, the guesswork is really taken out of this. So our hope is that for road projects, the home for that may be DOT, but for water projects, the home for that may be the EPA's Office of Water. Now, moving on real quickly here, I do want to talk about one recent group that we're involved with and a piece of legislation we look to support, and that is the Preventing Roadside and Work Zone Deaths Act. So the idea here is this is a bipartisan bill that's recently been introduced by a number of members of Congress, including some of our very closest friends and allies on the Hill, as well as a couple of members of Congress like Rob Bresnahan that actually have some construction experience. And the idea here is just to make our people safer on job sites, particularly those that are alongside busy roadways. It's also looking at safety for stalled vehicles along the side of the road. So it's kind of looking at addressing two problems in a single bill. This really kind of plays directly into the increased work that NUCA is doing with our safety program and our safety education and training program. But it's just an example of one piece of language that's already kind of floating around that we're hoping will be included in the highway bill. This is going to potentially deliver on many, many, many industry priorities, not just funding, but also some of these permitting, these safety, these long-term program stabilization, and various other regulatory priorities that we've had for some time. So very, very important bill. The last thing I'll say about the highway bill, keeping one eye on the clock here, we're going to talk about this thing a lot more over the next few months. It's possible, actually probable, that we'll want to do some targeted fly-ins to support these various industry priorities over the next few months and into next year, both working with some of our coalition partners on issues like safety, permitting reform, and transportation priorities, but also, moving SRF reauthorization along as part of this broader package. And I'll talk a little bit more about what some of the vision is for that at the end of this webinar. I do want to shift gears, though, now, looking with one eye at the clock and making sure we have time for questions. And I want to just briefly cover the Workforce Pell Grant program. So this is one that I'm just really excited to talk about and dive into more, because ever since I've been a part of NUCA's staff, this has really been a goal for this association and for the industry by extension. I have talked to contractors all across the country, manufacturers all across the country, and heard the frustration from folks about why is it so much easier to get federal financial aid to attend a traditional four-year university and study anything in that institution. And yet it is so difficult to get access to federal financial aid to go into the trades. And this bill has changed that for good, hopefully. And it's done so in a way that is, in many respects, actually a bipartisan compromise. There is work to be done to implement this, but it potentially is a game changer for the industry and opens up tremendous opportunities, not only for folks who are looking to get into the industry, but also for existing employees that are looking to take the next step in their careers, upskill, move to a higher paying job, a position of critical need, and just really, find a better path for themselves and their families. So I'm tremendously excited about this. The pathway to implementing this starts now, though, and it's going to take a lot of work for us to make sure that programs are actually available to meet our industry's needs. Eligibility for workforce Pell Grants begins July of next year. It expands eligibility under a workforce Pell Grant for programs between 150 and 599 clock hours and between 8 and 15 weeks. Previously, eligible Pell Grants had to be more than 15 weeks and more than 600 hours. So short-term programs are now a viable option. Eligibility is pretty similar for students as it is to existing Pell Grants. It's tied to income. You have to fill out the FAFSA. You also will not be receiving the full 7,000 and change maximum Pell Grant. It is prorated to the length of the program. So there are some obstacles still there, but it really is going to come down to program affordability at that point, because that is still a fairly generous amount of federal aid that is available to these programs. It makes sense to prorate in some regards for a program that's less than the full length of what a Pell Grant would normally go to. Now, the catch right now, among other things, eligible institutions are those that are accredited and able to receive Title IV funding under the Higher Education Act. They must meet job placement and earnings metrics, among others, meet a demonstrated industry need, and they have to have been offered for at least 1 year before a student can use a workforce Pell Grant for them. That means that NUCA chapters, especially if there is not any such programs at local community colleges right now or other accredited training providers right now that meet your chapter's needs, you need to start working towards that goal immediately. Because even if you get a program up and running tomorrow, when that deadline rolls around on July 1st next year, students will not be able to use a workforce Pell Grant to it until at least July 16th. So we're really on the clock here. Programs, once they're up and running, have to demonstrate some track record of success to receive federal dollars. That's actually part of why they said only accredited institutions can receive that money. There was a compromise after the parliamentarian initially ruled a broader version of this was ineligible under Senate rules to be included. But the longstanding concern around workforce Pell Grants was they would be so broad that anybody could, set up a school in their shed, say, I'm going to train people, and federal student dollars would be going to programs that didn't necessarily provide those students with skills to succeed in the workplace. So there's more requirements on us and on educational providers to make sure these programs are successful. Of course, in some ways that's good. We don't really necessarily want money going to programs that don't provide people with skills we need. But it also means that we need to work to make sure that those programs actually exist. Now, I know our Workforce Development Committee is already diving into this. There's also been some exciting developments in the safety, education, and training front that may directly link to these workforce Pell Grants. But this is really going to be a partnership between the NUCA chapters, state governments, and local accredited institutions to make these programs successful. It's something I'm very excited about, but it's going to be a lot of work from us to really take advantage of this. Two other things that I want to, well, three other things I do want to flag about this. Number one, the eligibility of non-credit programs is to be determined. That is going to be something that we really have to look into. There's going to be a rulemaking process for that. The distinction between credentialing, non-credit programs, training programs that are, guaranteed job placement type situations. There's a lot of questions about what this is going to mean. We had envisioned that we were probably going to be working with the Department of Education mostly on this. You haven't already seen the news. Department of Education, its future is a little uncertain right now, to say the least. There's an announcement from the administration a couple of days ago that the Department of Education and the Department of Labor are going to be partnering on a lot of this. So we're going to have to find out where that home for those rulemakings is. It may delay implementation of the program beyond July 1st of next year. Two other notes. The bill also allows 529 savings plans to be used for credentialing and job training, which is just another great change in our view. It's more opportunities for folks to pursue skilled trade education. And then we've talked before about the EPA's Innovative Water Infrastructure Workforce Development Grant Program. We're continuing to press Congress to fund that at a higher level. That may be a great opportunity for NUCA as a national organization, or at a regional level, some of our chapters potentially even, to go after some of those funds to develop these programs. And likewise, it would be, even if we didn't receive those dollars, a great opportunity for some of those accredited institutions or some of the partner organizations on the utility side to go after those to set up those programs. So that would be a nice little synergy for us, and we're hoping that Congress will continue to support that program. Now, we're going to start transitioning towards more of the challenges in a moment. I got one more positive note on permitting reform to come after this, but I do want to just briefly cover workforce and immigration. The legal committee, as you may have heard, is working on guidance around immigration and customs enforcement workplace actions, specifically compliance, best practices for maintaining your records, but also the rights and responsibilities of the employer and your employees, both on the job site before any enforcement action and during any enforcement action. This is particularly important and worth mentioning now because we do expect a significant uptick in enforcement actions over the next few years. There was an unprecedented expansion of ICE funding within the bill. It is an extremely large budget, and there will be a lot of hiring, a lot of expansion of their workforce aimed at enforcing the administration's immigration policies. So it is very likely that if you haven't already either yourselves experienced an enforcement action or heard of other contractors or manufacturers in your area that have experienced one, you may very well in the next few years, and we want to make sure that you're prepared and just well equipped with the knowledge of what to do in that situation. Of course, we encourage all of our members to comply with federal immigration laws and to comply with federal law enforcement, but we will provide you all with more detailed guidance with the disclaimer that I am not a lawyer and this is not legal advice from me. That is why the legal committee is involved. We are also continuing on a slightly more positive note to evaluate congressional and administration proposals for immigration and seasonal work visa reform. A bill that we took a look at last Congress, the Dignity Act, was just reintroduced. That's a pretty broad-ranging proposal for a lot of both immigration reforms, border security reforms. There's some work visa process reform in some of this legislation as well. So these are all things we're taking a look at, and our line continues to be, we support some sort of seasonal work program specifically for construction to help meet our industry's needs during times of greater demand for skilled labor. So that's something that we're also keeping an eye on. That may stand a better shot of success in this Congress and under this administration than some of the other broader ranging immigration reforms that were discussed during the last administration. So switching gears back to something a little more positive, permitting reform. Since the agreement that was reached to extend the debt limit under the previous administration, The average time to complete an environmental impact statement under the National Environmental Policy Act, NEPA, 2.2 years. The requirement under the FRA was 2 years. So we've made a little bit of progress, but 61% completed since that act went into effect have still failed to meet the statutory 2-year deadline. So permitting delays and inconsistent federal policy create uncertainty. They drive up costs, they delay projects, they lead to projects getting canceled. It's a major issue of concern for us still. It's something the administration knows they need to take action on. And we've been encouraged as the year has gone on at both some of the executive actions and some of the legislative actions that they've taken towards reforming our nation's broken permitting process. However, doing all of this through executive action is not a viable option for the sole reason, if nothing else, that many of our projects take more than 4 years. Some of these large-scale jobs take at least that long just to be approved. And the challenge, as exemplified by the Waters of the U.S. rule, is when you have administrations and a change of parties and policy just ping-pongs back and forth. We're under the third now WOTUS revision in as many presidents. It's not a sustainable pattern. And so really Congress needs to take action to codify and clarify as much of this as possible. Now, there were some baby steps towards this in OBBB. Project sponsors for certain eligible projects can now pay a fee totaling 125% of a federal agency's costs to receive an expedited environmental review. Agencies would have to complete that assessment within 180 days or an impact statement within 1 year. That's moving in the right direction. Obviously, we're not going to be huge fans of putting more and more of these costs on the private sector rather than the agency who's requiring the review. But, it is still a pathway to cut through some of the red tape that's slowing down these jobs. And then we talked about the Permit Act. Permit Act is primarily focused on the Clean Water Act, but this bill specifically addresses a number of the issues that we've identified for many years around the CWA permitting processes. As I mentioned, this would take some steps towards codifying a definition of waters of the U.S. that makes a lot more sense for our industry, in particular some of the exclusions around water treatment systems and the ephemeral features, the ditches by the roadside that they'll fill up with water when they rain, but otherwise they're dry. For any Florida folks on the call, I do want to specifically flag for you that this would require an EPA review of current regulations around the state assumption process for Section 401 Clean Water or 404 Clean Water Act permits. I know that's been an issue for many of our Florida folks. It's something I've heard quite a bit about down there. And one of the Florida members of Congress, Representative Petronis, I believe, his legislation to address that was included in the broader Permit Act. Our hope is this goes to the floor at some point next week. We have endorsed this legislation. We'll probably put out another statement when we know a better sense of when that timeline is. But broader permitting reform priorities moving just beyond the Clean Water Act do remain a priority of the congressional majority. I think there is some bipartisan room for some sorts of agreements here, but we'll have to see. It depends on really how bipartisan of a process the majority wants to make this. Obviously, there's only so much you can do without the buy-in of Senate Democrats. As we saw from OBBB, many of the permitting reform changes we would like to see are not eligible under Senate rules for that process. And so to go really beyond this probably is going to require some level of buy-in from Dems. And hopefully we do end up seeing a good bipartisan package that can make it to the president's desk soon. Now I'm going to switch gears and end on some of our ongoing challenges. And we've already covered possible federal spending cuts. We've already talked about workforce development and immigration challenges. I'm going to cover tariffs quickly in a moment, but so many of these things do still come down to that one word we talked so much about at the start of this administration, and that's uncertainty. There are a lot of questions about, I think, some of the timelines that the administration has laid out. We're certainly seeing that particularly apparent on the tariff front. But we just don't know what action the administration is going to take on some of these questions that are tied up in court, or tariffs, or even the likelihood that we have a government funding agreement in time to prevent a shutdown later this year, which could drag on for quite some time. A couple of the setbacks that I want to flag briefly, and these are not going to apply to all of our contractors, but those working in energy and broadband in particular. Unfortunately, I do have a little bad news for you. One of the biggest issues we had with OBBB was really around some of the energy projects. As we talked about a lot during the last administration, NUCA has adopted an all of the above energy policy, right? And we have members that work on everything in the energy space, from traditional, natural gas transmission and distribution projects over to, renewable energy jobs like solar and wind. The latter are in the crosshairs of this administration in a way that the former were under the last administration. And so now, we're really kind of putting we're taking our words very seriously. We meant it in the last administration when we said all of the above, and we mean it when we say it now. And so we were pretty disappointed with the path they took to phase out some of these renewable energy tax credits for large projects. In particular, wind and solar projects are going to lose out on a lot of the benefits that they would have had under the Inflation Reduction Act, much of which was repealed as part of OBBB. The one possible silver lining to this, the language is not as bad as was originally proposed. Projects that are placed in service by the end of 2027, or which begin construction by July 4th of next year, will still be eligible. And so hopefully for contractors who are looking to begin work on a large-scale wind or solar job, that project will still be able to move forward if the developer was counting on those tax credits to make that happen. Now, the White House is going to be looking at this pretty strictly. That was one of the ways that they were able to convince some of the House, more conservative House members to ultimately support the bill, was to promise that they weren't going to allow folks to really play games, particularly with that beginning construction requirement. So that may work to our advantage, but it's going to be a real challenge, I think, to get some of these jobs, to keep some of these jobs on schedule. And then for those who are working in the broadband space, unfortunately, the BEAD program continues to face delays. The federal government announced at the beginning of June a review, or they had finished their review of that program. The goal was the removal of unnecessary rules and mandates, many of which did slow down implementation of BEAD, but they also removed the fiber first preference, which means that utility contractors, telecom contractors who are working on those fiber projects, which is the most reliable form of broadband, are now going to be at a disadvantage compared to, in particular, companies like Starlink, which are going to be able to make a play for significantly more of that $42 billion in funding. The worst part of this is we were real close to beginning construction. States must now redo their entire proposals. The timeline for projects has been delayed significantly at this point, likely into late 2026 or beyond. And so of that $42.45 billion in broadband funding, not a single dollar has actually gone towards any fiber projects anywhere across the country yet. And it may be longer still, unfortunately. And then tariffs. And I know we're running low on time. We will keep this running a little longer after the hour to answer questions, but I did want to make sure I covered this. This is still a topic of concern in DC. We are still talking with lawmakers about the impact that it has to contractors. The biggest problem, really, more than potentially anything, is just the pattern at which these have been announced. We're not exactly getting a whole lot of clarity on what is and what is not subject to a tariff. The rates do, unfortunately, seem to change by the day, and it makes bidding projects very, very risky and very, very difficult, even for projects that are subject to Buy America domestic preference requirements. This is potentially going to drive up costs on a large slate of our materials for our manufacturers. Some of these costs are likely to drive up your input, the cost of your input significantly. If you'll recall, a few months ago when we talked about tariffs for the first time, told you all I was really worried about copper coming down the line, and the administration just announced pretty broad 50% tariff on copper imports effective August 1st. So we will see what happens there. We are still in the middle of what the administration says is negotiations with a lot of countries. But the path forward, perhaps of all of the areas where there's uncertainty, the path forward is the most uncertain here. So if you have not already seen this language from the NUCA Legal Committee, or for some reason you don't have this or can't find it, please do feel free to reach out to myself and the communications department directly. We will get this to you. This is the sort of language that the committee has endorsed. If you can use it in a contract, try to get it in there. Obviously, in some cases, particularly at the public level, that's not always an option. And we are working to try to get some better guidance and opinions from either states attorneys general, or at the congressional level, some action to make sure that contractors are not forced to foot the bill for what is effectively a tax increase on their materials. If you go to bid a project, and in between your bid being accepted and the project actually starting, we have a 200% tariff announced on a vital input that completely blows up your bid, eats into your project's budget, potentially even costs a contractor to lose money on the work. There is no reason why the contractor should be forced to bear responsibility for what is effectively a tax increase. So we are, rest assured, we have your backs on this one. We're fighting hard in DC to try to get you all some relief. But this is just a real challenge because the administration has been admittedly a little difficult to work with and a little opaque around tariffs, and especially around the idea of granting exemptions. So what's next? We've covered a lot. I'm going to move on to questions, but just so you all know kind of what the rest of this month and this summer looks like, appropriations really loom large. The deadline is September 30th for Congress to keep the government open. I would not rule out a shutdown. I'd probably put the odds about 30% right now of that happening. A continuing resolution is almost guaranteed. This is complicated by, the Dems kind of feel they got burned over the last continuing resolution. They delivered the votes to keep the government open, and the administration is continuing to try to claw back funding. You've probably heard on the news about them trying to pass a rescission package to pull money from PBS, NPR. So Dems are a little skeptical about making another deal, and the Senate needs their votes to pass a government funding bill. So that could be a very ugly fight, and it's possible that we will experience a shutdown at the end of September. There's also the question of impoundment, which we've heard the administration throw that word around a little bit. Can they legally refuse to spend money that Congress has allocated? A lot of the courts in the past have said no. It's possible they're looking for an opportunity to bring that fight back up. But that does mean that particularly some of the programs that they're not huge fans of, like some of the renewable energy construction projects and programs that are still around, that money may be at risk, and we'll have to keep a very close eye on what happens there. The biggest bill that's really left coming up, surface transportation and SRF reauthorization. Expect to hear a lot about that from us at National. That's going to be one of the main priorities for us, if not the main priority for us for the next year. And then they're already talking about another reconciliation package, probably beginning of next year. We may start hearing about that. They can do 2 or 3 this Congress under congressional rules. And we will see what potentially makes it into that. But that could be another, multi-month long fight / opportunity, the way that OBBB ended up being. Now, there are other legislative and regulatory updates that I could give. I will probably defer to questions given that we are at the hour. But, we're doing a lot of great stuff around a number of ongoing regulatory issues for us. The safety department has been real active with a number of the OSHA rulemakings that are in process. We've also been keeping a close eye on some labor-related challenges that the administration has kind of thrown in our way. But just rest assured, there's too much for me to talk about here, but if something comes up, particularly in questions, you'll probably be happy to know that we're on it. So with that, we are at the hour. For those of you who can stick around, I'm happy to take as many questions as folks have.
Thank you, Zach. Let's now open the webinar to questions. You can use the chat feature to submit a question, and I'll read the question to Zach. Or if you prefer, unmute yourself, state your name and company, and ask the question directly. Remember to remute yourself after you finish. And we do have one question, Zach. Does the NUCA Government Affairs team have any additional resources, tools, info related to the R&D expensing that has been reinstated?
Yes, so I'm happy to provide a little more information about that to folks offline. But the short answer really is that the changes that were made under TCJA are now permanent, or the research and development expensing. So that 100% expensing to allow you to fully deduct cost of new and used equipment and technologies used in research and development in the year purchased, that is now permanent. There is no danger of that expiring. That's I think a pretty significant win. And like I said, I'm happy to provide some additional guidance from folks who are tax professionals that can get a little more into the nitty gritty of what that exactly means. My email is on the next slide, so I'll put that up now. If folks
Are there any other questions? And I'd urge people as well too to use online resources for some of these business things. I use a site called jdsuper.com, which is generally a compilation of law firms giving out free advice. Take it for what it's worth. But I find a lot of very useful information about these relatively technical regulations. I learned things that I did not know about. Any other questions?
One other thing I should mention about that R&D expense credit, some of these, this applies to some of the other changes as well, but this one in particular, that is retroactive still. So if you are a small business with gross receipts of, I think it's 31 million or less, you can retroactively expense that back to after New Year's of 2021. So 12/31/21. All other domestic R&D between 12/21/21 and 2025 that can be expensed over a 1 to 2 year period.
Are there any other questions? Zach, there's nothing else, so I think we're at the end. Thank you everyone for your questions, and really thank you for your participation. We'd also like to thank our many new national partners for their continued and very kind support of NUCA and our advocacy efforts on behalf of the American utility construction industry. Today's webinar has been recorded. A recording of this webinar will be made available on our YouTube channel over the next few days. And thank you for your time today to join us for this special industry webinar and for supporting NUCA. Thank you for your time this afternoon, and please enjoy the rest of your week.